Breaking news out of the United States Supreme Court in the National Association for Gun Rights versus Naperville case dealing with these so-called assault weapon bans and the so-called large capacity magazines by the city of Naperville, Illinois, and by the state of Illinois. The United States Supreme Court has denied the request for an injunction. They have denied the request to enjoin that law pending the appeal process in the Seventh Circuit Court of Appeal, which is the Court of Appeals that oversees the Illinois federal courts. We're going to talk about what this means when we get back. Do not lose hope. It's not terrible news and it's not unexpected, but we're going to have to discuss it in detail in a moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check that out. We want to learn the lessons of the Ukrainians for disarming themselves so we don't make that same mistake here in the United States, and I don't think we will. Okay. So we have bad news, but not catastrophic news and not unexpected news. So let's tell you, let me give the facts, then let me tell you what it means. Bottom line is, today the United States Supreme Court, in an order, denied the application for an injunction. Just as a reminder, the National Association for Gun Rights and Mr. Bevis sought an emergency injunction, asked the United States Supreme Court to enjoin the Illinois law on the grounds that it violated the Second Amendment because the Seventh Circuit Court of Appeals, which is the federal court that oversees all the Illinois federal courts, that would be, again, the Seventh Circuit Court of Appeals, refused to enter an injunction that enjoined the law of Illinois that was essentially a gun ban. Now, what the Supreme Court wrote in a very cursory way, which is not unusual at all, quote, application for a writ of injunction, pending appeal presented to Justice Barrett, and by her referred to the court is denied. Now, this was highly expected, but I'm going to give you some good news in a second. The reason why this is expected, as you know, the Supreme Court, as a general matter, does not like to get involved with what are known as interlocutory appeals, which means appeals that occur in the middle of a case. They really only like to see appeals at the end of a case where a final judgment has been entered so that all the arguments, all the information, all the law, and everything has been fully developed, and then they can look at a complete record. They do not generally like to get involved prematurely for many reasons. Now, this is not a shock that the Supreme Court denied this request. It was a Hail Mary kind of request for an injunction, and I'm not surprised that it was denied. With that said, there is some very positive news that came out of this. Now, this is super inside baseball, and the press will 100% get this wrong. 100% will screw this up, so ignore the press, ignore any suggestion that this suggests the Supreme Court is avoiding the Second Amendment or doesn't care about the Second Amendment. Skip all those headlines. It's all nonsense because the Supreme Court has already altered in our favor the Second Amendment development involving quote-unquote assault weapon bans by virtue of the fact that when the National Association for Gun Rights sought this emergency injunction, Justice Amy Coney Barrett, rather than what happens 99% of the time in these contexts, rather than just deny it, Justice Barrett did something different. Justice Barrett insisted that the government defendants submit briefs explaining why they should prevail and explaining themselves, basically. That was highly unusual. And as a consequence of that, that did a couple things. One is it showed the Supreme Court where the anti-gunners or the government defendants were legally. And at the same time, this is where we had a major win, and you're going to see the consequence of this down the road in a few months. The Seventh Circuit Court of Appeals took that message from Justice Barrett that she was interested and concerned about the fact that the Seventh Circuit had not taken this seriously. Because remember, the Seventh Circuit refused to enjoin the Illinois gun control law. And at the same time, that same Seventh Circuit with a single judge, Frank Easterbrook, stayed the injunction enjoining the law entered by Stephen McGlynn in the Southern District of Illinois. So when the Supreme Court and Amy Coney Barrett issued that order that says, I want these government defendants to explain to me, what are you thinking? That signaled several things. It signaled something to the government, but most importantly, it signaled something to the Seventh Circuit Court of Appeals that they need to get off the pot, if you will, and get it right. So when the Supreme Court entered that order from Justice Barrett, it did a couple things. In addition to forcing the defendants to submit their briefs, it also required and scared, this is inside baseball, But the Seventh Circuit Court of Appeals got scared and realized they were on the verge of a very embarrassing spanking for screwing up and not doing their job. So as a consequence, while this appeal, or while this request to the United States Supreme Court for an emergency injunctive relief was pending, the Seventh Circuit Court of Appeals came out with an extraordinary scheduling order that said no more extensions. We want all these briefs filed, and we want oral argument at the end of June immediately. This is a huge deal. We've talked about this in prior videos because usually it takes several months for a case just to be briefed and heard at oral argument in the Court of Appeals. But here, literally the Seventh Circuit Court of Appeals, in fear of the Supreme Court doing something bad and embarrassing to them, they rushed this case along, put it on an expedited basis, and again, it's going to be argued, I think, the last week of June, which is quite significant. That is extremely fast. I know we don't think it's that fast, and certainly for gun owners in Illinois, I know you don't like that at all, and I don't blame you, and I don't like losing anything ever, by the way. Nevertheless, we have to be realistic about the realities of the court system and where we are in modern day America. Some of the stuff, we don't like it, but we have to deal with it, okay? So the bottom line is that because the Seventh Circuit Court of Appeals expedited everything and basically signaled to the Supreme Court that, okay, we got the message, we may have screwed up, but we're going to get this fixed and we're going to do our job. Please, Mom, please, Dad, don't spank me, don't embarrass me. We'll take care of business on our own initiative. And I explained to you that when the Seventh Circuit Court of Appeals did that, it was such an extraordinary act. It was really an act of contrition to the U.S. Supreme Court as I see it. And the Supreme Court is essentially applauding that behavior and letting that go. Now, this is significant. Now, usually you might want to see when an application for writ of injunction is denied that there be some sort of a statement made or maybe a dissent by one of the justices. But if you notice, there is no dissent, there is no statement made by anybody else, which is different, by the way, than what happened in the Second Circuit Court of Appeals out of New York City about 6 or 7 months ago when the Antonyuk case, which dealt with the concealed carry laws of New York, right? If you recall, there was an emergency request to the Supreme Court. In that case, Justices Alito and Justices Thomas issued a little statement saying, we're watching this case very carefully. We think the district court did a good job, but we're going to let the Second Circuit take care of business before we do anything. You don't see that here. The reason why you don't see that here is because, again, the Seventh Circuit acted with such extreme craziness in a way to expedite things, to say, oh, I'm sorry, I really am sorry, Supreme Court. That's why the Supreme Court is kind of rewarding them for taking the initiative and trying to solve this issue with speed. And that's why you don't even see a reference from Clarence Thomas or Sam Alito or anyone like that in the denial of the injunction, because I think they feel the Seventh Circuit understands the message from the Supreme Court. I know this is very implicit. It's very sort of nuanced, but that is the reality. And at the highest levels of this level of law, those subtle nuances can make all the difference among these various courts as to how they communicate with each other on these big ticket items such as the Second Amendment. So now the question is, what's next? Okay, so there's 3 things I want you to keep an eye on, and we will cover this. 3 things, though, if you're keeping score at home, there's 3 things to pay attention to. The first is you're going to watch the 2 consolidated cases right now in the Seventh Circuit Court of Appeals dealing with the injunctive, whether or not an injunction should be entered of the Illinois assault weapon / magazine bans, which it should. So you're going to watch the National Association for Gun Rights versus Naperville case, which is consolidated with the Barrett versus Rowell case. You're going to watch those cases that have been consolidated pending right now in the Seventh Circuit Court of Appeals with oral argument scheduled around June 25th or so. So that is one thing you're going to watch very carefully, what happens there. You're also going to watch the pending case before the Supreme Court of Illinois. This is unlikely to go well for reasons many of you have pointed out, given the composition of the Illinois Supreme Court and the fact that that challenge is based on the Illinois Constitution, which means that no matter what the Illinois Supreme Court does, they're not ruling on the Second Amendment itself. They're actually ruling on the Illinois state constitution, which is not something the U.S. Supreme Court really has jurisdiction or say over, because it's up to the Illinois State Supreme Court itself to interpret the Illinois state constitution as a general matter. So the first case, again, is the National Association for Gun Rights versus Naperville. The second thing is in front of the Illinois Supreme Court, and that is a series of cases. But again, that deals with the state constitution, and I'm not holding out a lot of hope there, given the composition of that court. It doesn't look very friendly to gun rights to me. Nevertheless, that's the second thing you want to pay attention to. And the last thing may be the most important case, and may be the case that goes to the U.S. Supreme Court next, dealing with these issues. Specifically, this is a case called Veramontes. I think I'm pronouncing that correct. But the Veramontes case is a challenge to the Cook County quote-unquote assault weapon ban. So it's actually a ban in Cook County, which of course is Chicago, that banned quote-unquote assault weapons before Nice River versus Bruin. That case, and this is why I say this may be the most important case going to the Supreme Court, you'll see, is because they are right now, as we speak, I believe, litigating the summary judgment motions. Now, the reason why that's significant is based upon who the judge is. This is my best guess. That judge in the Northern District of Illinois, that federal judge, is almost, in my guess, is going to rule against the Second Amendment plaintiffs, which means that the Second Amendment will suffer a loss in that federal court in the Northern District of Illinois. It's on summary judgment. The reason why that is important is because when that judge rules against the Second Amendment on summary judgment, that will be the end of the case. It will be a final judgment in the Veramontes case out of Cook County in that federal court system. And because it's a final judgment, if and when they take an appeal, the Second Amendment plaintiffs, the Second Amendment supporters take an appeal to the Seventh Circuit Court of Appeals. What is different about that case? For those of you watching this channel, you know what's different and why it's important, which is that will be a case, the Veramontes case, will be a case arising in the Seventh Circuit Court of Appeals on a final judgment. Unlike the National Association for Gun Rights case, which right now is still on an interlocutory appeal basis, which means between, the case is not over yet and won't be over yet. It's sort of dealing with preliminary injunction at the start of a case almost. But the Veramontes case, assuming summary judgment is resolved in the next several months, and the Second Amendment plaintiffs lose, which I think is likely. You got a Chicago federal judge. I'm not that optimistic about the Second Amendment there. If that were to occur, you'd have a final judgment against the Second Amendment, and that is not an interlocutory judgment. So as a consequence of that, you will then see an appeal out of that case to the Seventh Circuit Court of Appeals, but the procedural posture will be much, much more favorable for the Supreme Court to take that case on a quote-unquote assault weapon ban, because again, it will be based on a final judgment where the case is completely over and fully litigated, and the Supreme Court 99% of the times prefers to see that as opposed to ruling on an interlocutory case where it's not complete. And they don't like things that are not complete because they don't want to miss anything, because whatever the Supreme Court does, it has a ripple effect across the whole country. So they really don't like to make mistakes, because the mistake gets compounded. The mistakes get compounded extremely fast because everyone pays attention to every single ampersand, comma, and footnote the Supreme Court says. So that's why they're very careful and only like to hear cases at the end. And that's why that Veramontes case out of Cook County in the federal system in Chicago right now may be our next best hope to go to the Supreme Court on quote-unquote assault weapon bans. Now, the last thing I want to mention, I know we're getting way ahead of ourselves a little bit, is some of you may ask, well, what about a circuit split here? Is there going to be a circuit split? The answer is a circuit split, which is a classic way that the federal court wants to step in and resolve a circuit split. And what a circuit split is, that one court of appeals in one part of the country says X, another federal appeals court in another part of the country says not X, so you have a conflict or a circuit split, meaning the same federal law or the same constitutional right has two diametrically opposite interpretations by two separate courts. That is known as a circuit split. The Supreme Court usually likes to step in and resolve the circuit split and make a final answer once and for all, because you want the whole country and all the federal courts to basically apply the same federal law, including the same constitutional rights. That is what you want. So they don't generally like circuit splits. So the question is, what if there's no circuit split? The answer is it does not matter, because the Supreme Court has taken many, many cases over the years that they find to be particularly important, even if there is no circuit split. Moreover, there is also the possibility of what we saw in Caetano versus Massachusetts. And I know I'm getting way ahead of ourselves, but I want to give you, because it's my job to make you the smartest person in the room, and I don't care who else is in that room, I'm going to make you smarter than anyone in that room, even if they're fancy dancy lures and fancy shoes and fancy French cuff outfits or PhDs with sweaters. I will make you smarter than them on these issues. If you watch this channel, that is at least my goal. And anyway, so I mention this because there's also the possibility of something called summary reversal. The United States Supreme Court does occasionally do summary reversals. I think the best example of that in this context is the Caetano versus Massachusetts case. In the Caetano case, remember, there was no oral argument, there was no cert grant, there was nothing. It was simply pending. The Supreme Court took one look at the absurdity of the Massachusetts Supreme Court in upholding the Massachusetts ban on stun guns that the Supreme Court literally issued like a 5-paragraph decision in Caetano that says this is an absurd ruling. We're granting cert and summarily reversing the Massachusetts Supreme Court on the Second Amendment, and Caetano is a great example. So I think, and there's been talk about this in the past, about these kind of quote-unquote gun bans are so inconsistent with Supreme Court precedent. I could see a situation where the U.S. Supreme Court could summarily reverse a decision out of a place like the Seventh Circuit or some other court of appeals that upholds a quote-unquote assault weapon ban, because as you know, notwithstanding the political propaganda terms, these are simply nothing more than semi-automatic rifle bans, which are clearly not allowed based on, among other things, the Heller precedent and, of course, Caetano. So, okay, bottom line is this. That was the breaking news out of the Supreme Court today. The request for an injunction was denied. The Illinois gun control laws continue in effect. That is terrible news on the one hand, but it was not unexpected, and I think the Seventh Circuit Court of Appeals is going to move fast. And by the way, do not count out the Seventh Circuit Court of Appeals. There is still a reasonably good chance that the Seventh Circuit Court of Appeals will rule in favor of the Second Amendment. So do not think that we're going to lose in the Seventh Circuit Court of Appeals. We could very easily win that. We'll know a lot more in the next few months, and I will keep you informed as events move forward. Okay, folks, hope this wasn't too geeky for you. Look forward to talking to you, some of you down there in the comments. And again, we'll see you again next time here at the Four Boxes Diner. And don't forget to subscribe.
Orders up. Table 2A.